welcome to Rightly Decided, the mostly originalist takes of the litigators of the Texas Public Policy Foundation. I'm Laura Beth Latimer, and I am here with attorneys Nathan Seltzer, Clayton Calvin, and our special guest today, Heidi Walusimbi. Heidi, like me, is a former prosecutor, so we're bringing you a criminal law roundup today. Some of the cases that have dropped this session. The first one dropped back in January, so it's a little bit older. And then a denial of cert from last week that we're going to try to break down a little bit. But let's start at the beginning with Case v. Montana. Heidi, will you go ahead and lay out for us the facts of this case?
Sure. So what we have here is Mr. Case. He was on the phone with an ex-girlfriend and they were having an argument. And apparently Mr. Case had been drinking fairly heavily. He started making some suicidal statements. He told his ex-girlfriend that he was going to go write a note, that he had a firearm, and if she were to call, any police to his home, that he would harm them. Well, during this conversation, at some point, the ex-girlfriend hears a click. She thinks it might be the cocking of a gun, and then a loud snap or bang. And then she calls for Mr. Case, tries to speak with him, and doesn't get an answer, and then the line goes dead. So she calls law enforcement, and she meets with them over at Mr. Case's house. She, relays the details of her conversation with the police. The police go to his neighbor's house. The neighbor confirms that Mr. Case's vehicle is outside in his driveway. And so the police, they knock on the front door, they go to the back door, they're calling for Mr. Case, he won't answer. They look through the window and they see a notepad, they see an empty gun holster, and they see a bunch of beer cans strewn around. And one thing that the ex-girlfriend told...
Let me interrupt you real quick. Was this law enforcement's first interaction with him, period, or had they had previous interactions with him in the past?
They had previous interactions with him. They knew that Mr. Case had tendencies to drink heavily, and he would get suicidal while he did so. And then on at least one prior occasion, Mr. Case had tried to initiate a suicide by cop.
So they get to this house, they're looking through the window, they see a note, maybe some handwriting on the note, they see an empty holster, they have all of the context of the girlfriend's phone call, the 911 call. What do they decide to do, and how long does it take them to do it?
So given their prior interactions with Mr. Case, they don't go in right away. So they're not sure if he has, indeed harmed himself, or he's going to, or if he's getting ready to do so. But they are also a little bit leery because of his previous attempt at this suicide by cop. So they call their chief. The chief arrives on scene. They talk about some safety concerns to themselves. They don't know if Mr. Case is going to try to start any kind of firefight. They retrieve some ballistic shields. They retrieve their own long, rifles, their own firearms. And it takes them about 40 minutes before they actually enter his home.
And just to be clear for everyone, like suicide by cop is like the guy is going to potentially try to start a gunfight with the police in order to die. So like that's the concept behind what they're concerned about, right?
And they're aware
Exactly.
of this. The cops are.
Yeah, cops are walking into the situation already knowing that this is a possibility. Okay, so Heidi, what happens when they go into the house?
So they go in, they start calling for Mr. Case. They don't hear anything. He doesn't respond. So they start, doing a sweep throughout the house. One of the officers goes to a bedroom, and lo and behold, Mr. Case is hiding behind a curtain in a closet. Mr. Case opens up that curtain. The officer sees some kind of dark object in Mr. Case's hand. He thinks it might be a firearm. So the cop shoots Mr. Case, hits him in the abdomen, and starts giving him, life-saving treatment right there. Another officer comes up into the bedroom, and he sees a black firearm in a laundry basket right next to where Mr. Case had been standing.
So Mr. Case is charged with assault of a peace officer, right? Because he's ostensibly, theoretically pointed a gun at the cop, and then he gets shot in response to that. The main issue here, as framed by the court, is whether or not this violated, the entry of the officers violated the Fourth Amendment. The way that the court phrases it is whether police officers entering a home to provide emergency aid need, quote unquote, probable cause to believe that an occupant is in peril. We're going to talk more in a minute about what probable cause means, but the answer that the court gave, in effect, was no, they don't need probable cause, but with a big asterisk next to it. So, Clayton, can you give the government's best argument here as to why they didn't need probable cause to enter this house?
So basically they relied on a case called Brigham City, which seems to be like pretty much right on point. But like I said, all that they needed was an objectively reasonable basis to believe that Case may have been seriously injured or at risk of imminent harm. And this is the emergency aid exception to the Fourth Amendment.
I'm actually going to stop you right here because it occurs to me that we haven't actually defined probable cause yet. So this is not the most helpful, probably, distinction to draw.
Okay.
Heidi, you want to give us the definition of probable cause?
Sure. So, quick definition, it's a standard that officers need to meet in order to effect an arrest. So, what probable cause basically is if a reasonable person would believe, based upon, the objective facts and circumstances known to them, that A, a crime has occurred, and B, that the suspect is the one who committed that crime.
So when we're talking about like beyond a reasonable doubt, and then, clear and convincing evidence, and then more likely than not, and then probable cause and reasonable suspicion, we're talking about some evidence, but not even more likely than not that an offense has occurred, right?
Exactly.
And for the folks listening at home that are like, wait a minute, what's the crime? There's no crime alleged here, right? Like we have no one says that he did anything wrong. At the point that they're opening the house,
until the point that they're going in the door, right?
Yeah.
No one is alleging that he had committed a crime.
That's the time they needed probable cause. If they were going to go in on probable cause with a warrant or something like that, that's the time they would have needed it. Is when they went into the house, but they don't even think a crime occurred.
If they were investigating a crime, but here they were only trying to render emergency aid because they thought this guy was in trouble. It had nothing to do with like stopping a crime or finding evidence of a crime.
Right. So in general, when we're looking at a situation like this, we'd be talking about the exigent circumstances exception, right? Which is where some sort of exigent circumstance, something emergency-like exists, coupled with probable cause, allows law enforcement to act quickly without need for a warrant, which brings us to kind of this interesting question of how does the warrant exception apply to the Fourth Amendment?
Yeah.
Clayton, can you give us a 10,000-foot view of the Fourth Amendment and why we need a warrant exception for it?
Well, sure, yeah. I mean, the Fourth Amendment protects our right to be free from reasonable searches and seizures. Presumptively, what a reasonable search, a search is presumptively unreasonable without a warrant. But there are other situations in which a search can be reasonable even if you don't get a warrant. And that there's a whole landscape of jurisprudence around what those exceptions are. Here, though, we're talking about like more of like a Fourth Amendment exemption rather than an exception, because they're not trying to clear the hurdle of the Fourth Amendment as much as they are saying that because they were just trying to render emergency aid, they actually didn't need like the warrant or the probable cause or what all the different boundaries standards are that you were just describing.
Right, which goes directly into that question of what standard do we need to have an exception to our warrant, or in this case, an exemption to our warrant to enter this home. The defendant's argument here was, we've got to get to that probable cause bar. If you're going to say that you can enter my house, you have to show essentially exigent circumstances. He's saying you have to show that there's an emergency situation and also that there's probable cause that I'm committing a crime. And like Nathan just pointed out, there's no crime at this point. Suicide is not a crime in the state of Montana. So the fact that he may or may not have committed suicide is not helping law enforcement with their need to get into this house.
And this is important for him. He's making these arguments because, he committed an assault, as Heidi was describing. He committed an assault. He pointed the weapon at the officers, and he wants all that evidence excluded. So he wants to say that the Fourth Amendment, you violated the Fourth Amendment, so you can't. I can't be put in jail. That's why he's arguing.
There's a whole other component here, though, which is that if they're in his house unlawfully, then he actually didn't commit an assault. He was just defending himself, right? And so there's that's also lurking in the background on this whole thing, that if someone comes into your house and they kick the door in like the cops did or whatever, and they don't have a lawful basis for doing so, you can defend yourself and you can defend your property. So and especially in Montana, like that's lurking in the background also.
So the core issue here is the government allowed to use this evidence in trial? The evidence specifically being the gun, and also being the offense itself to a certain extent, because those witness statements about the offense itself are going to be excluded if they are fruit of the poisonous tree. That is, if they've obtained that information by doing something unconstitutional, which brings us to the interesting question of the exclusionary rule. And we'll get to that, I think, in a few minutes. But at core, the court decided that no, we don't have to have probable cause in order to get this exception to the warrant requirement under the Fourth Amendment, because it is, like Clayton said, it's an exemption, not an exception. This isn't applied to the Fourth Amendment in the same way. And therefore, we're not asking the question of, was a crime committed? And probable cause and reasonable suspicion are determinations of when a crime has been committed. So instead, we're asking the question of whether an objectively reasonable person could enter to render the necessary aid under the circumstances. Does anybody want to try that? To say that in a simpler way than I just did, because I feel like that was extremely complicated.
No, I think that made sense. Yeah, basically the government was just saying, and the court ultimately held that you don't have the standard here. We're analyzing a different thing. We're not analyzing, did the government clear the hurdle in a criminal context pursuant to a criminal investigation of Mr. Case. There's a different standard that applies because there's a different situation at hand, which is just that was there an objectively reasonable basis for the government to enter to come render emergency aid?
So what?
I don't know if that was clearer than what you said.
I don't know. None of us practice criminal law anymore, so I'm just going to chalk it up to that. So Heidi, how do you think that this is different from objectively reasonable? How is objectively reasonable different from exigent circumstances?
Well, I mean, a lot of the language ends up being similar, right? There's this whole talk about, reasonable person, based upon the objective facts and circumstances. And I think really, what differs here is that with exigent circumstances, exigent really just means urgent, right? Dire. So an emergency. So exigent circumstances, we think of things like, destruction of evidence or like a hot pursuit where the officer literally does not have the time to go get a warrant before something untoward is going to occur. So, for example, an officer sees someone, fleeing an armed robbery and that person has a firearm and he suspects that person is indeed the individual that committed that crime. Well, if he's chasing after that suspect and that suspect runs into a room, into a house, the officer can't just go, wait for a warrant before he goes into that house to go arrest the suspect, especially someone who's armed and dangerous. He's going to go right through that home and he's going to apprehend that suspect. So, but that's immediate. That's something that needs to happen right away. Here, there's, this risk of serious harm or, a threat of serious harm. But again, it takes the officers 40 minutes. And I think the court is saying, well, there's a lot of things going on, especially on their knowledge of Mr. Case's prior interactions. And there's a risk to officers, and the actions that they're taking objectively are reasonable, even though it takes them that bit of a time delay. So I think we're almost splitting hairs outside of, again, what's happening immediately and what's allowed for a time delay based upon specific facts that are in this situation.
And I think that leads to sort of my objection to this. This might be the first time that we've actually voiced some objection to what the court's done. So
yeah, we can share our own
get
thoughts
into it. Yeah. My beef with the majority here is that I kind of think that they answer the wrong question. I think that the question that's actually in front of the court that they don't answer is a question of quantification. How much evidence do we need before we can kick this door in? Because I don't think that anybody anywhere would disagree that they could kick this door in to make sure that there's not somebody inside who's bleeding out on the floor, right?
And I don't think anybody did disagree along the whole appeals process.
Right.
All the courts agreed with that.
This is, and every judge on the Supreme Court agrees with that. This was a unanimous decision. And even when, I think it's Justice Kagan, writes a concurrence saying that Justice Sotomayor writes a concurrence also agreeing, saying maybe we should have handled this differently, but absolutely they could do this. No one disagrees with that. The question that I think is actually being asked is how much evidence is required for law enforcement to know before they can kick the door in.
Yeah, they sort of treated this as like, okay, we're going to answer the question about what legal standard applies.
Right.
But in agreeing that this was an appropriate conduct they kind of left out the
they
meat of the matter.
They left out the meat of the matter.
They answered the linguistic, legal answer, but they left out the sort of substance.
Right. The question that they were answering was, is probable cause required? And the answer to that is no. But for law enforcement, that's a really unhelpful answer because they need to know what is required in order to kick down that door. So they quote the Montana court, the Montana court that used its community caretaker doctrine, and they say the court goes out of its way to say that this is an incorrect statement of the law, but I tend to agree with this statement of the law. Under their community caretaker doctrine, the court explained, that is the Montana court explained, the police could enter a home to do a welfare check only when objective, specific, and articulable facts would lead an experienced officer to suspect that a person inside is in need of help or is in peril. The Supreme Court, our U.S. Supreme Court, did not agree with that language. They said, no, the question is just, is it objectively reasonable? But that's a really, really broad thing to say, and it's not actually tied to anything. Gorsuch in his concurrence gets into this a little bit more and gives maybe some meat on the bones of what objectively reasonable means. But I think this language is really helpful, this specific, objective, specific, and articulable facts that would lead an experienced officer to suspect that a person inside is in need of help.
It would be very helpful if that was the standard.
It would be a very helpful standard.
If that were a federal, I can kind of see where the Supreme Court is coming from, though, because so when you say the Montana court, you're talking about the Montana State Supreme Court,
yes,
not
the Montana
like the federal
State
district
Supreme
court or
Court.
anything.
Yes, yeah.
And so the Supreme Court is just saying, hey, excuse me, this is federal law. Like the Fourth Amendment is in our federal Constitution, and we are the federal Supreme Court, and we're going to decide what the bounds are, what the standards are. And you, the Montana Supreme Court, when you're applying, maybe you can, when you're applying your own state right to be free from unreasonable seizures, okay, you can define what that is in whatever language you want. But if you are talking about the Fourth Amendment in the federal Constitution, you need to use our language. That all the states have to be uniform in this.
Right.
So I can see where they're coming from, although perhaps they should have just adopted Montana's test for the whole country or something.
It would have been helpful. And then that kind of brings us to Justice Gorsuch. And Justice Gorsuch ties this back to a completely different place that's a little bit foreign for us prosecutors nowadays, but ties it back to common law property rights. So, Clayton, I'm going to bounce this question to you. What is Justice Gorsuch saying about common law property rights and how that applies to this case?
So he's saying, he joins all the other judges and all the other courts that have decided this case as it's gone up and said, yes, this was a valid entry into the home. But in classic Gorsuch fashion, it's like in the tariff concurrence where he's like, yes, we all agree, but you're all wrong about why we agree.
But you're all wrong.
Every single one of you is wrong. Here he's kind of doing the same thing. He's like, yeah, we agree, but all of you are using these as he says, the miasma created by the Katz era. Katz was a case that maybe Laura Beth and Heidi can explain.
No, Heidi can explain that one. My grasp on it is not good enough.
Wait.
But what he's saying is like, basically there's this whole area of Fourth Amendment jurisprudence that's just based on the intuitions, the miasmatic, which is Nathan's favorite word.
Love it.
Brings it up all the time. Miasmatic intuitions of 20th century justices who happen to be on the court. And that's all well and good. I'm sure you're all very wise, but let's actually root this, ground it in law and history. And that way it's objective and it doesn't evolve. And our Fourth Amendment rights don't like ebb and flow and grow, shrink. And they've kind of shrunk actually because of the way that the court has been doing it. But he says, no, if we root it in the common law, then it's sturdy and it'll be with us forever. And so basically what he's saying is the Fourth Amendment entry, the Fourth Amendment basically tracks common law ideas of trespass. So rather than a reasonable expectation of privacy, which is the modern bounds of the Fourth Amendment that trigger the Fourth Amendment, we say, no, if you would have trespassed at common law, then you've violated the Fourth Amendment.
And I just wish that Gorsuch's opinion was the lead opinion. Like, that would be amazing because, like, to me, he's pointing at what a private citizen can do in this situation. Like, if you're walking by your neighbor's house, you see that there's a suicide. It's a little sketchy that there's a suicide note that they can see as a suicide note from outside the house.
They had heard that there was a suicide note and they saw a note.
But
it sounds like they were
this
like
grocery list. Like
Yeah.
I think
They saw a notepad, right? They saw a notepad, and
They
there was
saw-
mention
Yeah.
that he
They were
was
like,
going to
"Oh,
write a suicide
He
note.
definitely wrote a suicide note on that notepad.
Okay, yeah,
Reasonable
so-
inferences, guys.
so. Like there's a little bit some sketchy facts. Like they had to look in the laundry basket to find the gun. Like why are they looking? They're just trying to help him. Why? So there's some sketchy facts here. But a reasonable person knowing everything that law enforcement knew. The court is saying, or at least Justice Gorsuch, I think, is saying that a reasonable person could have kicked in that door just like law enforcement did to go help Mr. Case.
And it would not have been, they could have used the private common law defense of necessity if they were then sued for trespass.
Right.
And that's the same standard that the government should be able to use when they are trespassing.
So go ahead.
That completely answers my beef with the majority, right? Because I'll admit that it's sparse because very few people who are dying on their floors sue the guy that kicks in the door and then saves their life.
Yeah, right.
But there is actually common law precedent about when it is appropriate and when it is necessary, objectively necessary, for someone to walk into someone else's home to save their life. We do there's some teeth on that. There's some meat on that. So Gorsuch's opinion answers that, but it does lead to a really interesting problem, which is that we no longer use common law trespass. Nathan, why don't we use common law trespass when we're dealing with Fourth Amendment issues anymore?
Because there's this court-invented doctrine called qualified immunity, which basically prevents what it used to happen is if an officer were to arrest you and they didn't have probable cause, you could sue, like in a situation like they went into your house or they did something that violated your Fourth Amendment rights. You could sue them for trespass and you could get damages, and then they could, as a defense. They could raise that, no, we had probable cause.
It's like typically like in early America, you could just sue the government like you would sue a person and say, you came into my private property and this is no one else is allowed to do it, so you're not allowed to do it. It's like, it's the whole Lockean thing that government only has the powers that are delegated from people.
Straight into my veins. Go.
Yeah. If a person can't do it, in the state of nature within the social compact, they can't delegate that to the government. So therefore, you can sue the government for trespass, but...
Yeah, and so, but then eventually the court created this doctrine called qualified immunity, which I'm not a huge fan of, and it allows the government to be immune unless you meet certain criteria that it's clearly established that this is a violation of someone's constitutional rights. So it's very hard in most situations to sue the government for trespass. It's almost impossible.
Or for anything.
Or
for damages, for like anything.
So notwithstanding that there's a statute specifically that Section 1983 that allows people to sue the government, it's very hard even so. And so the government, in order to get around this, all of a sudden people were having their Fourth Amendment rights violated and they had no remedy. They couldn't sue the government about it. They couldn't do anything. They would just go to jail, just go straight to jail. And so the court created this doctrine of the exclusionary rule, which says that, okay, if they do violate your Fourth Amendment rights, they can't use the evidence that they obtain in violation of the Fourth Amendment. That's how we get to all this doctrine that's at play
so
here.
Basically, they invented, so we started off in this perfectly clean, clear, originalist state where you can sue the government for trespass, and then the government invents a doctrine called qualified immunity to insulate the government. Did I say the government? The court invents this doctrine that insulates the government from immunity. And then to offset this invented doctrine, they create another doctrine that's invented called the exclusionary rule that says that, okay, fine, government, if you're going to trespass, we're just not going to let you use this as evidence against the defendant, which as Americans, we've come to know and love and be very used to, the exclusionary rule. But it is invented, and it's invented as a reaction to another invention.
Yeah, it is. It's invented, but like we don't want to go back to a world where there's no exclusionary rule and say, well, that's invented, let's get rid of it,
right? Because
then you still have the problem of qualified immunity.
Yeah, so you don't get to do half originalism.
Yeah, there's no half originalism here, because if we say, oh, sorry, no exclusionary rule, that's not originalist, but we leave qualified immunity on the books, there's absolutely no remedy, and the Fourth Amendment might as well not even exist.
It's kind of like if we were to, for listeners of this podcast, but we'll later talk about the unitary executive and major questions doctrine and all that, but it's like if we, in an effort to be originalist, gave the president the power of the unitary executive, but then also allowed Congress to delegate all of their lawmaking authority to the executive branch.
Take it all.
Then
we'd have a king.
Then we just have like an emperor.
Yeah.
So we can't just do originalists in one hand and not in the other hand.
Yeah.
So it's the same thing here. We want, as of now, we want the exclusionary rule.
But it wouldn't be a bad situation to go back to the way it was at the founding, where there's no qualified immunity and there's no exclusionary rule, and it actually would simplify things. Mm-hmm. But because we have like court-created doctrine on top of court-created doctrine on top of court-created doctrine, then here we have what seems to be another court-created doctrine, which is this reasonable, objectively reasonable basis for a person. But the thing that I like about this one, the way that Justice Gorsuch conceptualizes it, is that it applies whether you're a law enforcement officer or whether you're a private citizen or anyone else. And to me, that is really hearkening back, and he does connect it back to the founding and the way the common law operated.
Mm-hmm. It's basically just tethered to the private defense of necessity as a defense to trespass.
Yeah.
Right.
So in effect, just long story short, if Justice Gorsuch was king for a day and this opinion was just to the absolute law of the land, this would go back to that criminal trespass standard, i.e. objective reasonableness, what we have in the common law. If an officer does something that is not objectively reasonable in order to save this person's life, that officer is liable for criminal trespass and can be sued for criminal trespass, but the evidence wouldn't be excluded under the exclusionary rule because we wouldn't have an exclusionary rule. Now, of course, he doesn't walk down that whole train of abuses, if you will.
That's something
but
for another
that's
case.
kind of how this would track if we were following a truly originalist perspective.
Mm-hmm. I just feel bad for all the police training manuals and stuff that now have to be rewritten to add yet another chapter.
And I think it's important to kind of draw some attention. Again, this is my beef with this opinion. We know as prosecutors, we know as law enforcement, Heidi, you can back me up on this one. We know what probable cause is. Like, we deal with it every day. We're telling officers, yes, you have probable cause for this. No, you don't have probable cause for this. And law enforcement is making traffic stops sometimes hundreds of times a week on the basis of reasonable suspicion. They know what that is. It's workable. It's doable. This objectively reasonable nonsense is just kind of throwing them to the wolves and saying, I hope you're right about what's objectively reasonable. Good luck.
Well, isn't it correct?
Well, I think this is
wrong.
almost like any other.
Oh, I'm sorry. Go ahead.
Any other standard, though, right? I mean, I'm sure when reasonable suspicion first, came about, and that's has to be just more than a mere hunch. Everybody's looking around at themselves like, what does that even mean? And then trying to differentiate that from probable cause. Well, when does it transform from reasonable suspicion to probable cause? I mean, so, yes, it is new. And yes, I think it does leave officers in the dark. But, at the same time, anything that's new, any new standard, any new doctrine is going to take time to implement, to understand, to get trained on. But I think what is interesting about this opinion and the majority's, a little bit of their defense, I guess, is that they are kind of taking pains to say, look, probable cause is firmly within a criminal context. We do not bring it into, this emergency aid exception because there's no criminal investigation occurring. And I think their beef with the Montana Supreme Court's language is that it tracks too close to reasonable suspicion. And I think they're trying to keep these things separate, from each other. So that's my kind of, a little bit of devil's advocate defense of, the majority's kind of issue with how Montana originally framed it in their standard on the community caretaking doctrine.
Now, I absolutely agree with you that that's what the court is doing, and what they're trying to do is say, no, this doesn't fall into our normal hierarchy, right, of reasonable suspicion and then probable cause and then clear and commit. Like, they're saying it doesn't fall into that hierarchy because the question isn't, was a crime committed? They're saying it's over here in its own little wonderland. But even like with reasonable suspicion, it's not just reasonable, it's reasonable articulable suspicion. So like there's some boundaries on how we know that it's more than a hunch. Can you articulate the things that person is doing and why they make you think that a crime is occurring? And that same kind of concept is wrapped into probable cause as well. But when we're talking about being off in a wonderland of a new era of standards, we don't know what that suspicion actually is or what that objectivity requires, I guess. And you're right. It's going to take some time, but everything takes time. I just wish they had tied it and said, as far as quantity goes, how much evidence are we looking for? Is it more like probable cause? Is it more like reasonable suspicion? Is it somewhere in between the two? They seem to be saying it's not as high as probable cause. But there's a way to read this opinion where they're saying it's actually higher, but the government met it here. So I don't know.
Well, remember though that the officers are still going to be entitled to qualified immunity.
That's true.
Like if they don't get, I mean, this is actually probably a good example of law that is not clearly established. I mean, clearly it's not. This came out the other day.
Came out in January, yeah,
so,
a few months ago.
So if they get it wrong, I don't know. I guess I'm pushing back. I'm not as sympathetic to the law enforcement in this situation. I mean, or to their. I don't know how much more difficult this really makes it for them, because if they get it wrong, insulated by qualified immunity, and
well, it doesn't change.
And also is it really that difficult to? Because basically what this is saying is practically. You have all these standards that cops are used to, probable cause, reasonable suspicion, everything, but those just apply to if you think that a crime is being committed. Cops know whether they're trying to investigate a crime or whether they're trying to render emergency aid, and this opinion basically just solidifies that divide. And if they're going in, if they're saying, "Oh, we're not going to stop a crime from happening. We're just going to go help this person."
Right, but that's different subjective reasonableness. If my subjective decision that I'm going to go render emergency aid is the standard, that's not what we're talking about here. This is objective reasonable suspicion or objective.
Aren't all the standards that cops use objective?
Yes.
Okay.
Which is why saying that the officer says I'm going to go render aid versus I'm going to kick in this door because I want to know what's inside that house gets a little fuzzy around the edges.
I'm sure it does.
Especially if the phone call that comes in is a 911 call from the known girlfriend of the president of the local gang, and she says, "Oh, he's got a gun and I think he's going to kill himself," hangs up the phone. Like, is that enough evidence for the officers to then go kick in the door, especially if they really want to know what's inside that house?
And if they're in a state where like maybe suicide is a crime, which I don't know if it is in
I don't think
Montana,
it is in Montana from the case.
But yeah, or like if the girlfriend were there and she was like, he's going to kill himself and me, then it is like in pursuance of crime.
What I'd like to see here. Oh, go ahead.
Well, sorry, but then wouldn't just the normal standards that you were describing apply, because it would be a criminal investigation?
If there's a crime, yes, but if it's just we want to know what's in his house and we've been given this almost pretextual reason to say there's an emergency and go in. So like, I think that you misunderstand where my concern comes from. I'm not concerned for cops at all. I'm actually concerned for the general public, because if cops don't know how much evidence they need, they can just whittle that down basically to nothing and say, "Oh, well, I got this phone call and it was 10 words that said, this is..."
And this is not clearly established. There's not been a case like this.
What I'd like to see, and if it was Justice Nathan writing this, Justice Seltzer writing this opinion, is I'd like to see them be able to go in and help. If you need to help the guy who's going to kill himself or might have already killed himself, and you really feel like it's aid, right? You're just trying to help. You're not investigating a crime. Go in and help. But it doesn't matter what evidence you find in there. If there's meth stacked up or there's guns everywhere or whatever, you can't use that evidence. That would be, we'll just extend the exclusionary rule over this evidence that you find because you didn't go in investigating a crime. And if there is a crime or something like that, then you get your warrant or you get your exigent circumstances exception or whatever, and you go in under those you go in under those exceptions. But if it's really emergency aid, you don't get any evidence.
Yeah. Heidi, I'm curious how you feel about that. He and I talked about this earlier, so he already knows how I feel about it. I want to know how you feel about it.
No, I mean, the concern obviously is there because, I mean, pretextual, issues have come up before, right? I mean, they used to come up with traffic stops, in the 90s before, Renvy versus United States came out, and there's always this kind of, I think, hesitation or a little bit of wariness that comes into, well, usually the court isn't considering what an officer's subjective, reasoning might be, right? They're just going to look objectively at, facts and circumstances. But, if they enter a house to render emergency aid and they see, let's say, a pile of methamphetamine on the table, my fear is that the court wouldn't extend any sort of exclusionary rule. They might say, well, that's in plain view and that's another exception. And you can't expect an officer to turn a blind eye to, blatant law breaking.
And you'd end up in essentially the same place that you're sitting right now. Like it just turns into basically what we have right now. And my concern about it is what do you do in a case like this where the offense is then committed in front of you? Like, what if it's exactly like this? You do something that is unlawful. under the Fourth Amendment on its regular terms, kick the door in, and he points his gun at you, and now you have a crime. So is the whole crime suppressed just because you're trying to render aid under the emergency aid exception? Or like what, Nathan, what happens with that in your theory?
So I think that you would treat that like an interaction between two individuals, not law enforcement. So however that would come out with tort law, did each actor act reasonably, like in a self-defense scenario or something like that? If the officer's in there lawfully,
and this is Justice Nate.
This is Justice Seltzer.
Yeah, to be clear, we're departing into our own.
Yeah. Maybe we should not. Maybe we should stick with
I think it's real. No, it's fun. It's like,
but like however that would shake out, if it was two private individuals, because that's basically the emergency aid exception. The way that I'm kind of taking Justice Gorsuch's opinion and expanding it. The emergency aid exception applies to private individuals. So you would just the police officer is actually acting in his private, just like any other citizen could do. He doesn't have any additional authority in this case. And so if he acted reasonably and then the other person acted reasonably in their response to him, then maybe there would not be a result. But the main concern that I think that we're trying to get at here is that there's evidence that was obtained of crimes as a result of this rendering aid thing. And I don't like that. I think that that's dangerous. We're just trying to help, and then you got arrested. Right. I don't like that. Which
is exactly why I think that it would be helpful if the court had given us some standards, some words by which we could say, here's how much evidence you need. Mm-hmm. You know, a call from the scorned ex-wife is not enough. If she says, he's been really depressed recently and he has a gun, that's maybe not enough. But if he calls the police and says, I'm going to kill myself in 5 seconds, that's probably a little bit better.
Well, yeah. I mean, but to be fair to the court, you don't want them to be giving advisory opinions about hypothetical facts and stuff. And all of Fourth Amendment law and other areas of law are based on the facts of whatever the case is. Like, we have to look back at the landmark Fourth Amendment cases and analogize our present case to that, whatever case we were litigating, to those cases there. So, here people will be like, well, in case there was a potential suicide note, there was a notepad on his couch, and so on and so forth. So, I don't know. I'm just being devil's advocate.
I think that was Heidi's exact point, which is we're just going to have to see how this plays out. My heart hurts for the people that might get hurt while we're trying to sort it out. And I appreciate, and you're absolutely right, that the court can't do advisory opinions. But I do think that they missed an opportunity here to give some sort of to give more than 2 words, to say more than just reasonably objective or objectively reasonable.
Yeah. You didn't think the opinion was clear enough.
More than that, to just kind of help guide this and say, based on what we already know of Fourth Amendment jurisprudence, or based on what we already know of criminal trespass jurisprudence. Thank you, Justice Gorsuch, for that little hat tip. But we'll see. All that to say, we will see how this pans out in the future.
I want to say one more thing about Justice Gorsuch's concurrence. He's doing this a lot lately with these concurrences that are like, if we just interpreted this the way the founders did, this would be so much easier.
Yeah.
And he just kind of drops that out there and just drops it out there.
It wouldn't be subjective or miasmatic.
Yeah,
it would be clear, and it would be grounded in law, and you'd look at precedent from
and history. I just want to see more of that. Like, just keep going, because
takeaway is Gorsuch is right.
After this podcast, I'm going to need one of you to define miasmatic for me. Okay. Let's move on, because we've only got 7 minutes, but we can do this in 7 minutes. It's a dissent that we have from Justice Gorsuch, a dissent against a denial of cert.
Do we call this a dissental? Is that what the word?
I refuse to call it a dissental. I think that sounds like something a middle schooler would say, even if it is something that...
no offense to the lawyers listening who use the word.
Yeah. This is... I'm a first-generation lawyer, for what it's worth, so I'm learning all these things as I go. Okay, so this dissent from Justice Gorsuch on the denial of cert... Heidi, can you explain, because I tried this earlier and failed, can you explain what the core issue that Justice Gorsuch identifies here is?
And real quick, denial of cert for anybody listening is that this was petitioned. This case came up to the Supreme Court. The Supreme Court said, we're not going to take it at all, and we're not going to decide it. And Gorsuch dissented from that denial.
Yes. So he would wanted to take.
He wanted to take the case.
Yeah. And because I don't think I said it before, this is Burnett v. United States. So Heidi, can you tell us what Justice Gorsuch is concerned about here?
Sure. So the crime that, Mr. Burnett was convicted of had a maximum prison sentence of 120 months, which is 10 years. But what he agreed to in a plea deal was that he would be incarcerated for 105 months and then have 15 years of supervised release to follow that. Now, what ended up happening is Mr. Burnett did his term of imprisonment, started on supervised release, violated his supervised release, then was sentenced back to prison. He didn't hit the maximum of 120 months yet. He hit about 118, got put back on supervised release, violated again, and at that point, the government sought to imprison him yet again for an additional 14 months. And once they did that, he ended up serving 12 months longer than his statutory maximum for that crime. So instead of 10 years, he served a total of 11 years of imprisonment for his crime. And Justice Gorsuch is saying, wait a minute. How is he serving more time in prison than what the maximum is for this crime? This seems a little odd that, we're going above the maximum here. And anytime you violate supervised release, you actually don't get a jury trial. You just have a proceeding with the government, defense counsel, and the judge. And the standard isn't beyond a reasonable doubt. It's something called preponderance of the evidence, which is more likely than not. And the concern is, well, is this violating a Sixth Amendment or Fifth Amendment right to a trial by jury?
And we don't get an answer to that. We don't know why cert was denied, but we don't get an answer to that. We just have Justice Gorsuch saying, hey, we need to address this because this is really important. I do think for the sake of understanding why the court did what it did, it's important to draw the distinction between the different kinds of supervised release and how they're different in the federal system versus the state systems. So in the state systems, at least in Texas, there's some of them are a little different. So if your state's different, I'm sorry, don't shoot me. In Texas, there is probation, which is served in lieu of, it's a suspended sentence. It's in lieu of prison time. So it is a supervised release in the sense that we're keeping an eye on you while you're on probation. But there is no prison time that has to be served first. Parole, on the other hand, is the supervised release that occurs after a prison sentence is not completed, but some of it is served, and then the person is released on parole for the duration of that sentence. So, for example, in Texas, if you are sentenced to 7 years on, we'll just say, an aggravated assault or something, you serve 50% of your time, and you're eligible for parole. The parole board decides, you know what, he's really trying hard. We're going to give him a chance. Let's him back out for 3.5 more years. That's the length of the supervised release, is just to that 7-year mark, nothing beyond that. So your sentence is 7 years, and 7 years is how long you're going to serve. Now, with probations, that's a little bit more flexible, setting that aside. In the federal system, you're sentenced to a prison term, and then after your prison term is served, you are sentenced to a separate term of supervised release. And those are both definitive terms. So you can be sentenced to 10 years, or it's usually in months, so 120 months. And then you're sentenced to an additional 15 years of supervised release.
And so like this 120-month statutory maximum is only for the prison time?
It's only for the prison time.
Okay.
And this is a really unique kind of statutory framework here because there's a separate statute in addition to the sentencing guidelines for this particular offense that says that this particular kind of offense, because this was a human trafficking case, actually. I think Justice Gorsuch doesn't draw attention to that, but it is. It's a child sex trafficking case. Yeah. That is the underlying offense. And in these cases where human trafficking or trafficking of a minor is the underlying offense, the period of supervised release is from 5 years to life. And that is mandatory to be attached to whatever sentence is given. Mm-hmm. So if he had served all 120 months on the front end, if he'd been sentenced to that, by statute, he still would have had to serve 5 to life of supervised release afterwards.
What happens, like say you serve the whole 120 months, I don't know all this law. What happens if you violate your supervised release and you've already served the statutory maximum?
That's the exact question that's being asked in this case. You've hit that nail on the head.
Okay, good.
What do we do? And the answer, according to, I think it's the Third Circuit. It's the Third Circuit. And according to the Supreme Court is it's fine if you have to serve more. Now, the it's fine is coming from kind of a weird place because it looks to me like a waiver. I think this is an appellate waiver that the court is saying is appropriate and appropriately executed. So he pled guilty to these offenses. And as part of our guilty pleas, across the board, people who accept a plea are waiving their right to appeal. And because this is coming up on a direct appeal, that was waived by his accepting of the plea deal. And even though this is arguably an illegal sentence, that waiver is still effective, which I think is the reason. That's my best guess as to the reason that cert was denied here.
Yeah, okay. So you're inferring that this is probably why. Because, Gorsuch's, the points that he's making in this dissental seem really important. I'm making dissental happen.
You're making dissental happen.
But all the points about the Sixth Amendment and like you can't just be put in prison longer than the statute allows just because the judge, by a lower preponderance of evidence rather than reasonable doubt, like makes you extends your prison time. This is a big Sixth Amendment issue. That all seems like extremely reasonable and something that the Supreme Court should take up. And so it's like, why is Gorsuch the only one who cares about the rules, as it were, to quote the Big Lebowski?
I think part of it is that...
And it's probably this. It's because procedurally there was this defect. Maybe the rest of the justices are waiting for a more appropriate case.
Yeah. And maybe also because the guy is not sympathetic at all, right?
Also Yeah, bad man stays in jail is a very real thing.
Yeah.
Is this the thing you want before the court where you're going to give like a defendant more rights?
Well, it would be a very robust way to protect Sixth Amendment rights because everyone would know, well, if this applies to child sex traffickers, then it applies to every defendant, which, is not good. But Sixth Amendment protections are good.
Right.
You could see why they wouldn't want to deal with that.
It's a bad look, but... Yeah.
But in order to get there, they'd have to resurrect a waiver of appeal. And as soon as the court starts doing that, the plea deals are going to plummet in the United States. And that would just cripple our system.
Right.
The whole system would crumble if we were to start doing it that way. So I can see, at least in theory, why we wouldn't take this case. But it is an interesting question. And I hope to see the court kind of address this in an appropriate case, if you will. In an appropriate case, address this issue, because there is something kind of messed up about serving more than the maximum sentence on a term that you have been sentenced to. Yeah. I think that brings us to the end of today's docket. We're pretty close to out of time. So if you enjoyed today's podcast, enjoyed our conversation, please leave us a review and join us next time for more Rightly Decided.